Welcome once again to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you decide how to protect yourself, your family, and your business when it comes to legal matters. It's information and resources that'll help you decide that you may want to manage some issues yourself, or at least you'll be better prepared to work with the professional counsel that you select. Our goal, of course, either way, is to help you save time, money, and achieve the best possible results. We once again want to thank and welcome David Bazar from the Bazar and Associates law firm in East Providence, who continues to give us his insights, his anecdotes, and information about the various issues that we tackle. So last week we talked about COVID-19 changes affecting the legal system and your access to justice. So today we're going to discuss how your accidents, insurance claims, and various personal injury cases are impacted. More importantly, what you need to know because of the coronavirus, how it impacts your life, what you need to know, what you need to do. In the last segment, we talked about how many of the cases, the courts are closed, cases are postponed, delayed, others are being handled remotely. How does that impact on what happens to you on a given basis, whether it was an automobile accident or perhaps even slip and fall? So, David, you always weigh in on the legal matters.
Sure.
So tell us what's going on in the climate as far as personal injury cases go.
Well, here's, I think, what people need to know is that they can't sit on their rights. If you were injured and there's a clock that should be on that you need to know about, that is running, the statute of limitations. The courts can't and haven't said we're going to toll the statute of limitations, so to speak, because of the coronavirus. So if you were hurt in Rhode Island or Massachusetts and it's a personal injury case and you had 3 years from the date of the injury to file your lawsuit, that 3-year statute of limitations still applies. So you have to file your lawsuit within the same time frame.
Okay, but what if the courts can't get round to it? Suppose it doesn't matter?
It doesn't matter if the court can't get to hearing your case. The courts are open because we now have electronic filing.
Remote,
and
yes.
The courts are saying, yeah, you have some things that we can't do, and we may extend the time frame to do some of those things. But as far as bringing your lawsuit, you still have to bring it within the time frame that's always been required.
So these days, since so many people have been shut down and staying in, good news, there are fewer automobile accidents. Bad news, when people do have automobile accidents, I hear, I read, I understand that there are people who are more likely to be aggressive in their defense, and things are more litigious, and people don't want to go to the doctors if they've been in an accident because of the added risk. Sometimes people aren't paying their insurance premiums because they are in financial difficulties. Have you been finding that, and has that impacted cases?
Well, it's interesting. Couple of things that you raised there. During the shutdown, so to speak,
yes,
there are a lot less accidents.
Right.
And so insurance companies actually reduced the rates for many people on insurance because they weren't getting as many claims. The claims that existed prior to the shutdown and the ones that we've been working on that we either had just put in suit or were getting ready to settle, people were working remotely for insurance companies and are still working. And a lot of those cases I find have been settling and been settling for reasonable amounts of money. Those cases that haven't settled, arbitrators are still hearing cases and they're going through arbitration, sometimes through Zoom or other kind of remote access types of vehicles, but those cases are still getting done and resolved. The only things that really aren't happening are jury trials right now, and so that's on hold, but cases are being settled, or being handled and moving forward. There is an issue for people who did have accidents that either couldn't get to a doctor because the doctor wouldn't see them,
sure,
couldn't do physical therapy because they were shut down. I think those things are going to have to be taken into consideration for people who were hurt and were injured as a result of an accident or other negligence. And couldn't treat the way they normally would, still had pain and suffering and had issues, and so we'll see how those things play out. Those are still new, and we're seeing where they go.
Seems like I almost want to jump away from auto accidents and talk about, is that medical malpractice? But let's stay with the automobile accidents for a moment, or something like that. So insurance companies are supposed to help and pay for whoever did something wrong and all the rest. What happens now when someone has an automobile accident and the insurance companies say, maybe they're financially unstable ground,
Yeah.
let's get it all taken care of,
Right.
you don't need a lawyer, we're all set.
The same rules, I think, apply now as applied before we had a pandemic, and that if you have a personal injury, a lawyer is in a much better place to advise you, tell you what you're entitled to, and help you through a settlement than doing it on your own. If it's a situation where you couldn't treat but you were hurt, you maybe were able to go to an emergency room and be seen, but not a doctor on a regular basis, or it was by the telephone appointments or whatever they were doing. I think a lawyer is going to be in a better position to argue your case for you than you're going to be able to do with an insurance adjuster on your own.
And I would imagine that there would be many people who would be very inclined, very tempted to take the quick cash and because they need it.
Hey, sometimes you have to do what you have to do, and
Yes.
Insurance companies will dangle something out to you. It may not be totally enough to compensate you, but given your circumstances and whatever it is, it may be something that you just want to take because you feel it's in your best interest at the time. I can't tell people not to do that.
Have you found that there are fewer people who are calling about automobile accidents just because there are just fewer accidents, fewer cars on the road?
While we were in the lockdown stage, absolutely.
Yes.
But no, it's been busy.
Yes.
Since we've been opening up a little bit, phase 3 for a while longer in Rhode Island apparently. But people are out, people are driving, people are having accidents, people are getting hurt. We've been very busy.
So if someone does contact you now and they don't have any noticeable cuts, bruises that need to be stitched or whatever, do you find that people are unwilling to go to a hospital or doctor for examination because they fear the risk factor due to the pandemic? And what do you say to them?
Yeah, so you still need to treat, and given the circumstances we have right now, I know many doctors are seeing patients again. They'll go through a protocol just like our office will to make sure that if you're coming in, you haven't been exposed to someone who has been tested positive for the coronavirus, and that you don't have the COVID-19 symptoms. But the doctors will see people, and chiropractors will treat people. I know that we're sort of in a stage where you can be seen by doctors, and if you're having problems, you should be seen by a doctor.
And is there ever any question now about whether or not telemedicine stands up in court? So we didn't actually get to scope you over the phone or through Zoom. So how does that work now?
The doctors will probably be doing the same kind of reports that they did when the person came in live. They're probably doing these medicine by Zoom or other type of a device where you can see the person, talk to the person, you can't feel the person. I understand that, so there can be some challenge to, well, how do you know there was spasm? How do you know they were guarded? But it's a new world. It's what we're dealing with, and a juror who would sit on a case to hear somebody who was going through it at this particular time, I think could be made to understand that if they find your client is credible and the reports they gave to the doctor were credible, that the doctor's opinions are therefore reliable.
Okay. And now as the various gyms are opening up, we've talked about slip and falls before. If someone has a slip and fall at the gym, the floor was being cleaned and it wasn't quite dry or whatever the scenario was, how do you find that if that's happened, how do you handle those kinds of personal injury cases now that's different from what you would have done before?
So I don't think there's a lot of difference, to be honest with you. The same standards and rules of negligence apply.
Yes.
If you were negligent in maintaining the equipment, for example, in a gym, and that's what caused the injury, then I think the same kind of claim that would have resulted before we had this pandemic would apply to the situation now. Now, if you're saying you went to a gym and you caught the coronavirus because they didn't
Different story.
clean properly or whatever, there's a potential claim, but it's harder, and I think because we're still learning what we need to do and how to do it. But there are regulations that the state put out that says do this. If you didn't follow that, you may be opening yourself up to liability.
So we talked about this briefly a while ago, where unless someone was doing contact tracing, isn't it all but impossible to be able to say, I know I caught COVID from that gym and that elliptical machine?
Yep.
How would you actually know? That handlebar, was it you weren't there to swab the decks right at the time and check the handlebar?
It's very much a contact tracing issue. And so if there's contact tracing that's being done and it can get contact traced back to a particular place, then you can at least know that's where you got it. Whether there's liability for having gotten the virus there is a whole nother story, and it depends on all the other factors that would apply to any negligence case. Did they do what they were supposed to do? Did they do what a reasonable gym or a reasonable restaurant or a reasonable bar was told to do at the time? And if they followed all the rules, there's probably not negligence. If they didn't follow the rules and they didn't tell their staff to wear masks, and they didn't tell people coming in, we need to trace you, or not trace you, but screen you for the virus and everything, and they're not doing anything to protect people, then there is probably liability.
And if there's a slip and fall, if there's some sort of an injury such as that, and I am sure that someone, if they contact a lawyer, they would say, well, you of course have to go to a doctor, be examined. So maybe you got that to happen, but then there are subsequent appointments with various specialists, maybe your primary care doctor, and all of those things that I imagine go along with the typical personal injury case. I have read that there are people who are just too concerned to do those follow-up appointments. How does that impact what becomes a case that's likely to be settled before it goes to trial, and all? How does that play out, David?
If you don't follow up with proper treatment and you were able to, and it was just your own personal choice, it may impact what your case is worth and what you might be able to recover. Because it's one thing when you're in a lockdown and you can't go.
And you can't go.
You don't have a choice. So it's quite believable to me, and perhaps to a jury, if someone were to come in and testify and say, I was hurt, and I did all these things at home to try to help myself with this, and I called a doctor on the phone, or I had a telemedical appointment, but I couldn't go there because they couldn't see me. All right, well, what else are you going to do? That's reasonable. But if you come in and you say, I was hurt, and I could have gone to the doctor because the doctor would have seen me, but I chose not to, and I took care of it by myself at home because I was concerned, maybe if you're credible and the jury will believe that story, maybe, but the jury or a reasonable person could also look at it and say, well, how bad were you really if you could have gone and chose not to?
So if you're counseling someone, you're going to say to them, of course you have to evaluate the risks, but I strongly advise that you continue to take those appointments as they're granted or as it's requested of you?
Right, because I want you to weigh and balance what benefit you're going to get to make yourself better by going to the appointment against the risk of potentially getting a virus, a significant, serious virus. And what steps are the medical provider taking to protect you, to make sure that you're not at risk or that your risk is at least lowered. And so I know that doctors' offices have these screenings. I know that if you want to go see a doctor, many times they'll tell you to wait in your car, and we'll call you when it's time for you to come in, so there aren't a lot of people in the office all at the same time. I assume these offices are doing all the other screenings of their own employees, and chiropractors are doing the same, and physical therapists, I'm sure, are doing the same, so that there are precautions that are put in place so that you're able to receive the treatment that you need. So if you need the treatment, you should be going to get the treatment.
And when someone is injured, it makes sense that there would have to be some staging of it. It would have to be some continuity of care. And even for, what's that term? Something about the maximum or minimum medical...
Maximum medical improvement.
How do you get to know exactly what the baseline is, and how that's going to impact on how much money someone could or should get?
Right.
That impacts.
Yeah, I mean, it all plays into any treatment in any accident without the virus as being a component or layer over what you're going through. You go to treatment, the doctor treats you, the doctor examines you, the doctor makes a report, the doctor sees what your progress is, and at the end of the treatment, the doctor talks about whether or not you've reached maximum medical improvement. In other words, there's no more treatment that's going to make you better. And are you now back to where you were, as you said, the baseline prior to the accident, or is there some disability that you still have, a loss of use of something, your arm if that's what the injury was to, or some other body part, that the doctor can do a rating for and say, this is permanent and this is what you have suffered as a result of this accident or negligence. And that's all stuff that needs to be done in person, because the doctor needs to be able to measure your range of motion and to be able to talk to you and to be able to see you and feel you and touch you to know what's going on. So again, like I said, some of those things during the pandemic when we had the shutdown couldn't be done, could be done now, and if you don't get it done, why aren't you getting it done?
So do you find that while you're obviously going to suggest to your client do these things that they ask you to do, we'll have the documentation, I guess you need to call in expert witnesses at times. Does that area change now with COVID, that the expert witness isn't likely to be, well, could be Zoomed, I guess? Right. Is that how that happens in the case
we do
these days?
Depositions by Zoom or otherwise, so that they can be videoed and recorded and it's preserved for a trial. All of that can still be done. And again, I'm not telling someone to go and get treatment that they need if there's a surge and a lockdown again. But if you're able to, and the governor's done, both governors, Rhode Island, Mass, have done good jobs of telling us what the science is showing them and what the risks are, and telling us to be smart and go out and live our lives as we can given the current situation. So if the situation changes, I'm not saying, well, no, the governor's saying don't go to a doctor's appointment, but your doctor's still seeing you, but you don't feel it's safe. No. If the current atmosphere or environment is that we're not doing those things at this particular time, then don't do them. But if we're in a stage where we can do them, or a phase, and the phase 3, if that's what we're in, says you can go to your doctor, but the doctors have to follow these certain protocols, and they're following the protocols, that's when I'm saying you should go.
Okay. And then on the other side of it, a large portion of what you do requires that you negotiate, because many cases are settled rather than going to court. When you have to negotiate, when things are under COVID, not lockdown, but certainly in this phase that we're in, are you finding that insurance companies are more willing to negotiate, more willing to wrap it up, or are they more willing to say, let's let this play out, resolution left in abeyance indefinitely because they can? What happens?
So most of the cases that I've been handling right now, they've actually been very reasonable, and I think even more reasonable than prior to all of what's going on. There are some that haven't been, and I had one today where they made me an offer. I said, no, this is a component you need to know about of the damages, and they said, no, we're not going to consider that. I said, fine. I put that in suit today because we can draft the complaint, we can file it online. That's what we did. So if they don't want to be reasonable, then we'll put it in suit and we'll just follow it along. Because to get to a jury trial from a case that I put into suit today isn't going to happen within the next year, probably not even the next 2, but all of the other things that have to happen can happen. The interrogatories can still be sent out. The answers to interrogatories can still be filed. The motions that need to be filed can still be filed. Those motions are being heard by WebEx in Rhode Island, Zoom maybe in other states. But all of those, the processes of a case can still be heard. And the court annexed arbitrations that are required in Rhode Island before you get to a jury trial can still happen. A lot of them are happening by Zoom, but they're happening. So I wouldn't delay putting a case into suit. And like I said at the beginning, if you delay too long, you lose your right. So the statute of limitations still apply. So I put him in suit. And you know what? I'm confident that when the case I put in suit today would come up for a jury trial down the road, the courts will be ready to try those cases again.
They will by that time, you assume.
That's what I'm saying.
And on the insurer and the insurance company's perspective, we understand that there's an awful lot of fraud that goes on. So does that make them more circumspect in coming back to you and saying, Counselor, will you please provide more documentation, the recorded Zoom from the expert witnesses' testimony? Do you find that there's more of that because they want to, and they should, protect their own businesses and their own concerns about somebody being less than honest in what the presentations? How do you find that?
I find it's the same right now as it was before. The same concerns that they might have still exist, and maybe rightfully so. The ones that they were concerned about before, they have now. I don't find any new ones or additional ones, at least not yet.
Okay. So I've been speaking to you as a lawyer. If you put on the other hat for a moment, meaning you're also a mediator, have you been doing much work as a mediator relative to COVID and the cases that have come up, whether they're personal injury or med malpractice, well, whatever they might be, slip and fall?
I've done a fair number of arbitrations as an arbitrator.
Okay.
And those are able to be done with Zoom or video, because the testimony I can hear, the arguments I can hear and see, and I can observe the people. I'd like to see them in person if you gave me my preference, because I can see their face and their expression, but I can't see their foot swinging under the table or the knee knocking up and down, or whatever other body language you might want to see.
Yes.
It's not quite the same, but those kinds of cases have been going forward, and we've been doing a lot of those. Mediations I find to be a little bit more difficult. We can do mediations in the same way, but it's not quite the same as having the person in the room with you, so you can look them in the eye and they can know that you're there with them and you're telling them something and they're listening and hearing and understanding. It's not quite the same by video when you do that, but we have mediation scheduled, and we're going to do those, and we'll see how it goes.
So mediations these days on the family side of it or on the business side, or both?
Both. The mediation side and the family side. And so just, you know, I see clients, we take precautions in the office. When someone comes in, we have 3 conference rooms. We rotate the conference rooms. When someone sits in a chair, when they leave, they're sprayed down and disinfected, but then they're also taken out of the rotation and new chairs are put in, and they rotate out every 3 or 4 days. So we take those precautions. And since I do have 3 conference rooms for mediations, I have one that's really big where we can keep people separate and apart if they have to be in a room to start. But what I would do when I do them live again is have them in separate rooms and not even put them in the same room, and just go back and forth like you do at some point in a mediation anyway, where you're presenting offers and demands back and forth separately and privately. And so we have a way of keeping people separate. So I think at some point, if we can do that and keep people safe and clean those rooms and rotate the chairs out and keep people separate and apart, and more than 6 feet apart, if they're in the same room anyway, I would prefer to see those be done in person.
Do you think that there will be more mediation than usual because of COVID? Do you have any sense that that's likely to happen for reasons of time saving, money saving, expediency,
I think
whatever?
both mediations and arbitrations will there'll be an uptick, so to speak, not to use a surge language, but there'll be more use of that because people seem to be more comfortable doing that rather than going to a court building right now, and they can't even go to the court buildings for some of what they need anyway.
Sounds right. And what about, we didn't really talk about medical malpractice, but in the time that we have left, what would you have to say about how those kinds of cases certainly are likely to crop up for many reasons?
So the standard medical malpractice cases that you had before the coronavirus pandemic, you'll have after. The treatment of people, the same standards will apply. There will be an overlay of, well, the doctor couldn't see the person because of the shutdown or couldn't see the person because of whatever rules are, and that will all have to be taken into consideration. Claims for people who died as a result of having the virus, I think, as I said before, since it's new and the treatments are unknown, are very difficult claims to say that someone had a malpractice claim because of how they were treated. And I know on the federal level, I've heard some rumblings that they want to pass some liability caps or liability prohibitions based on this. I'm not sure that that's necessary, because I think, you know what, if somebody did something that was so outrageously negligent that it deviated from the standard of care and that they should be held liable for doing that, they should still be held liable for doing that, and they will have all the same protections of anybody else as to whether or not what they did violated the standard of care, because what is the standard of care when it's all new and you don't really know what's the best thing to do or how to do it? But if it was so outrageous that a jury would still find that they should be held liable, then they should still be held liable.
So without it going to that extreme, just telemedicine gives you, I would think, more occasion or likelihood that you'll have misdiagnosis. Not negligent, but misdiagnosis. They couldn't see, they couldn't feel, they couldn't hear, they couldn't smell, whatever it is. So that's not negligence, but bad outcome for a person might say, well, you didn't treat me properly.
If it doesn't deviate from the standard of care,
they don't have
then there's not a claim. Because a bad outcome in and of itself doesn't make a claim for a medical malpractice case. There still has to be failure to live up to the standard of care of a doctor in the same training, in the same circumstance as the reasonable doctor under those circumstances.
So if you get a call such as, I wasn't properly diagnosed, it took too long, I ended up with thus and such, I think I have med mal, you would say, no, you don't.
No, I would say, let's look at all the circumstances, come in and let's talk about it.
That sounds reasonable too. Well, as COVID does continue and you need to stay tuned, we say please do stay tuned to The Law Matters, because it matters to you. Thank you for tuning in.